United States of America versus Dana Frio.
Gentlemen, now which one's the appellant? You are?
Yes, Michael Clifford.
So, Michael, you go first then?
Yes.
Okay.
Chief Justice, and may it please the court, my name is Michael Clifford. I represent the petitioner, the United States of America. May I please reserve 3 minutes for rebuttal?
Certainly.
Thank you. Would your honors like a brief recitation of the case?
Please.
This case stems from an insider trade that occurred as the result of a conversation that happened at a party. The conversation happened first from a Mr. Alex Adams, who was a chief financial officer for the company iTech Holding. Mr. Adams had a conversation with Ben Bookwalter, who was a stockbroker, at which point in time he divulged confidential insider information to Mr. Bookwalter. Mr. Bookwalter then informed Ms. Corinne Cusick of this information, at which point in time Ms. Cusick gave that information to a Ms. Dana D'Onofrio. Ms. Dana D'Onofrio acted on this insider information and made a trade for opening bell that following Monday. Immediately afterwards, the SEC flagged this trade as insider trading and an investigation began. The district court held that Ms. D'Onofrio was guilty of criminal insider trading, and the 13th Circuit at that point reversed the decision on the jury instructions. We are asking that the 13th Circuit be reversed for the following reasons. First, the 13th Circuit used too narrow of an interpretation of the definition of both tippy knowledge and personal benefit. And second, if this narrow definition was adopted, it would create harm to both traders, the market, and the economy as a whole. Now, insider trading, there are four parts.
Let's go to the knowledge issue. Where's the mens rea?
The mens rea for tippy knowledge is willful. And in the context of the law, willful, in the context of insider trading, I apologize, willful is considered any defendant that intentionally acts with a reckless disregard of the truth. And this was held in United States versus Torello in 2004.
What circuit is that?
That would be the 9th Circuit.
Is that what all the circuits agree to?
All the circuits agree to the mens rea requirement for this, the 2nd Circuit and
How
the 9th
about the
Circuit.
definition of what constitutes mens rea?
A mens rea would be the mental state for which to
Do all circuits agree on that definition?
Yes, all circuits do agree on that definition, Justice Benjamin. And the four aspects of insider trading are that there was a breach of fiduciary duty, that this information was disclosed in exchange for a personal benefit, and that the tippy knew or should have known about this fiduciary breach, and the tippy used that knowledge to gain a benefit. In this case, Ms. D'Onofrio knew or should have known that the information that came from Ms. Cusick was confidential information. Ms. D'Onofrio was a sophisticated trader. She had discretionary ability to sell $10 million in iTech stock without any authorization from anyone else in her company. She would have shirked her duty as a stockbroker if she had not known when this earnings report was released.
Well, would you impose a burden on every person to check into exactly where information comes from when they get it?
Yes, Justice Workman. I do believe that a burden should be imposed when information is gained. And the extent of that burden, I would leave for the court to decide.
Well, how far, what's the white line that we need to have, the bright line? How far down the chain?
I do not believe we need to have a white line, Justice Benjamin, because this has to be looked at a fact-specific basis. If we use a bright line rule, this will allow insider traders to game the system. If they know exactly how far down the line they have to be in order to get away with insider trading, they will wait till they're at that point in the line, and then they will perform those actions.
Wasn't this information gratuitously given?
No, this information was not gratuitously given, Justice Ketchum. In this case, Mr. Adams was trying to get a reputational gain from the information that he gave to Mr. Bookwalter. Mr. Adams knew that he had a fiduciary duty, and the gain that can be gained, defined by insider trading, can either be pecuniary, reputational, and it does not need to be immediate. And the 13th Circuit erred when they stated that the gain must be pecuniary and the gain must be immediate. And,
Well,
and
the
this-
Second Circuit is against you, and they've had a lot more experience in this. Why shouldn't we defer to them?
Well, first, the Ninth Circuit decision that challenged the Second Circuit's decision in Newman, Justice Workman, was actually written by a Second Circuit judge. He was sitting in designation on the Ninth Circuit at the time, and I believe the reason for that was because he had quite a bit of experience in insider trading cases. I believe it was a judge from the Southern District of New York. In this case, if we look at the difference between Newman and Salmon, and there is a circuit split on this issue, Salmon states that just giving information to a friend would be enough. And Newman states that there has to be some sort of quid pro quo, and that also that the tippee and the tipper have to have at least a certain level of relationship between them. However, in this case, Ms. D'Onofrio meets both the requirements of Newman and Salmon as far as that knowledge is concerned. Ms. D'Onofrio would have had to have known that this was confidential information.
And that comes from the term "from good authority."
Yes. The minimum that she would have had to do, the minimum duty that she would have had to do to find out where that authority was from, was to ask, where did you get this information?
From good authority, could that not mean a trade publication?
Ms.
I mean, it could mean any number of things. Why should we impose on this defendant an obligation to automatically assume that from good authority means from bad authority, a bad person?
Justice Benjamin, because Ms. D'Onofrio was a sophisticated trader, she was in charge of over $10 million in iTech stock. She would have known exactly when this earnings report would be released. It was a Saturday evening. She knew the earnings report would be released on a Monday afternoon. There is no conceivable way that she would have thought that this information was not confidential. There is no possibility that a trade publication would release confidential insider information and that she would think that that information was from a good authority.
Aren't you assuming it's, I mean, from her perspective, what does the term "from good authority," how does that translate to insider? You're making a leap there. Why should we, as a rule of law, say, in this case, "from good authority" automatically equates to insider, as opposed to something else?
Because, Justice Benjamin, I think we need to look at not how the information was given to her, but what the information was. If you look at the nature of the information, the fact that it was confidential information, and the fact that there was no way that Ms. D'Onofrio could not know that it was
So
confidential
why do we
information.
even worry about the chain that that I asked about earlier? How far down the chain we go for the issue of knowledge? If it's just the knowledge itself, we don't have to go any further. If she's a stockbroker and she gets information of a certain type, she's automatically guilty. It doesn't matter if she knows where the source was or whether it was a legitimate source. She has to presume that, and we're going to find guilt based on a presumption.
Well, if you look at the way the other circuits have held before, they say that this knowledge can be inferred by the jury through circumstantial evidence. And if you look at the nature of the knowledge, and you look at the fact that she was a sophisticated trader, I think a bright line rule would not work in this situation, because you have a fact-specific inquiry. You have a specific type of information. You have a specific chain that information came down. And if you make a bright line rule, then that will just allow traders to avoid that rule in any given situation. Furthermore, if you look at the benefit that was gained by Mr. Adams and Mr. Bookwalter, those benefits were reputational benefits. Mr. Adams and Mr. Bookwalter both wanted to be the inside guy. As you know, in the financial world, knowledge is power. And the fact is, Mr. Bookwalter especially was building a stockbroker practice in which he wanted to come out ahead of his competitors. And the method that he chose to come out ahead was to use insider information that was given by Mr. Adams. And if you look at the general holdings in Solomon and Newman, if this court adopts Newman's broad interpretation and the 13th Circuit's broad interpretation of knowledge and data, it would do harm to other traders. It would create two classes of traders, a class of traders who had a greater amount of knowledge and a class of traders who had a lesser amount of knowledge. In this case, it would harm the market as a whole because these traders with lesser knowledge would withdraw from the market because they knew they were not on a level playing field. This would erode confidence in the market and also do harm to the economy as a whole. So if you look at the total set of circumstances surrounding Ms. D'Onofrio, you can see that she should have known that this was insider information, which is the standard that is used in SEC versus Dirks. The fact that she did not know specifically this chain of events is inconsequential at this point because she would have had to have known that it was insider information. And that Mr. Adams and Mr. Bookwalter traded this information for a reputational benefit. Additionally, the harm that could be caused would be great if these two classes of traders were permitted to continue. May I please have a brief moment to conclude?
Yes.
Therefore, for the following reasons, the 13th Circuit did use too narrow of a definition of both tippy knowledge and personal benefit, and adopting this narrow interpretation would do harm to both traders, the market, and the economy as a whole. We do ask that the 13th Circuit be reversed.
Thank you.
Thank you.
Chief Justice, may it please the court. My name is Colton Parsons, and I represent the respondent, Ms. Dana D'Onofrio, in this matter. The district court erred by instructing the jury with an impermissibly broad definition of personal benefit, and also erred by failing to require that Ms. D'Onofrio had knowledge of that benefit. The 13th Circuit vacated Ms. D'Onofrio's conviction because of these erroneous jury instructions, and that decision should be affirmed for the following two reasons. First of all, in the criminal context, insider trading law requires a fraudulent fiduciary breach. And here, Mr. Adams, the tipper, did not breach his fiduciary duty because he did not seek a personal benefit in exchange for the disclosure.
Then why did he do it?
He disclosed the information just as in a casual conversation with his cousin. He was frustrated that iTech did not listen to his advice, supported the iTech watch, and ultimately let it slip out because this is a kind of...
The operative word there is cousin.
Yes.
What's the law on familial relationships and information such as this being disclosed, tipping, so to speak?
In the criminal context, the Second Circuit held in Newman that absent a...
The Second Circuit's in your favor. What about the other circuits?
Right. The Ninth Circuit did adopt an intent to benefit, a trade relative or friend approach. However, the facts of that case are distinguishable from here. If you look at the facts, the initial tipper in Salmon was the brother of the initial tippee. He explicitly testified that he gave the information to his brother with the intention of providing a source of income to his brother. He was actually trying to provide for his brother. His brother then relayed the information to their brother-in-law, whom they were very close with, saw each other on numerous weekends throughout the year.
Well, in this case, though, you don't deny that, that Alex breached his fiduciary duty by telling his cousin about it, correct?
No, Alex did not breach his fiduciary duty
So
respectfully.
this defendant gets to walk away, I guess, scot-free under your argument with what, made $3 million off of this deal?
In the
something like
criminal
that.
context,
Uh-huh.
yes, I would say she did nothing wrong here. A insider trading conviction requires both a personal benefit from the original tipper and knowledge of that breach by the outside tippee. Here, there was no personal benefit nor any knowledge.
So is your argument that the knowledge standard is different in criminal and civil, that your clients could still be liable from a civil context?
I would say that she was still not liable from a civil context.
I use the word could.
Yes, she could potentially be liable from a civil context because Dirks contemplated imputed knowledge. However, Dirks was a civil case and did not investigate.
Why would she be liable in the civil context?
I said she could be liable under the civil context if the
Why
jury
would-
finds that she should have known of the personal benefit. But that's assuming that a personal benefit is found.
Your client's a smart trader,
Right.
obviously. Why should we endorse a standard of basically a person being able to just willfully ignore common sense here? I mean, obviously, from good authority, you know, wink, wink, nod, nod. The standard you seem to be asking us to adopt is one of allowing sophisticated traders to be willfully ignorant and benefit to the tunes of millions and millions of dollars. Doesn't, if we go along with you, doesn't that just nullify the whole concept of insider trading and the criminal consequences for doing that?
Yes, I'd like to make a couple points for that argument. While she is likely considered a sophisticated investor, she still did not realize that her act was wrong under the securities laws. The Securities and Exchange Act requires a willful mental state. And Ms. Cusick told her the information came from good authority, but she didn't know who that authority was, nor who the source of the original information was. I would also like to talk about the willful blindness standard.
Well, didn't the government prove that she knew that Ben's cousin worked for the company?
No, there is no evidence in the record to suggest that Ms. D'Onofrio
Knew anything about it?
knew that Mr. Adams worked for ITEC. Back to the willful blindness. Because this court held in United States versus Global Tech that willful blindness exists only if a defendant takes active steps or a deliberate action to avoid knowledge. Here, Ms. D'Onofrio did not take any active step or deliberate action to avoid knowledge. She was told the information came from good authority, and that's all Ms. Cusick would tell her. I'd like to get back to the personal benefit requirement, if that's acceptable. In the criminal context, the Second Circuit established that a personal benefit requires a quid pro quo exchange, and the relationship must be more tangible than an elevation in social status. The court held that in the absence of this meaningfully close personal relationship, and that generates an exchange that is objective, consequential, and represents at least the potential gain of pecuniary or similarly valuable nature, and there can be no breach by the insider tippee. Here, Mr. Adams did not personally benefit because he did not disclose the information for personal gain. He never received anything of material benefit from Mr. Bookwalter and didn't actually think the information would be traded on. He knew Mr. Bookwalter didn't own any ITEC stock. He knew that he routinely advised his clients against owning ITEC stock because of its volatility. He didn't invest in computer companies. That's stated in the record on page 3 and 4. Mr. Adams was merely carrying on a conversation with his cousin, as the 13th Circuit described.
Did he know who his cousin came to the party with? 'Cause
Who? I'm sorry.
Did Alex know who his cousin came to the party with?
There's no evidence in the record to suggest that he did.
I thought the record reflected that that he came to the party with Corinne.
He knew they were best friends, so he could likely infer that they came to the party together.
Okay, and then and that she was a big trader also.
He didn't know that she was a big trader.
Okay.
There's no evidence in the record to suggest that. I mean, he could have inferred it. Even if this court
So
had,
what you're saying is he was just complaining to his cousin.
yes, he was essentially complaining to his cousin that the people above him, he didn't listen to him about this ITEC watch. I'd like to turn to the knowledge requirement. We've talked a lot about the willful standard, and in the criminal context, it's important because under the Securities Exchange Act, Section 10B, the circuits are not split. This is a statutory requirement that requires a willful mental state. In both Dirks and O'Hagan, this court has held that there is no general duty between all participants in a market transaction to forgo action based on material, non-public information. The tippee must know the information was given to them in a breach of fiduciary duty. In other words, Ms. D'Onofrio must have known that Mr. Adams received a personal benefit. Here, Ms. D'Onofrio did not act with the requisite mental state of a culpable tippee because she did not willfully violate insider trading law. Tippee knowledge of the insider's personal benefit is required by traditional mens rea requirements. The Securities Exchange Act is simply a codification of these traditional requirements. The Act limits criminal liability to those who act willfully. So if a conviction turns on the existence of a fact, then the defendant must know that that fact occurred in order to be culpable. Here, the existence of the fact was a personal benefit, as we've alluded to, and this is a line between illegal and legal conduct. Thus, absent a tippee's knowledge of this personal benefit, she cannot be convicted. While Ms. D'Onofrio was at the party where the conversation took place, she did not hear what was said, nor did she know Mr. Adams personally. If you look at the record, page 4, she had already contemplated selling her stock for several weeks. And while this added information likely contributed to that sell-off, as this court has held, receiving and trading on non-public information is not by itself illegal. There must be knowledge. Thus, her conviction should be vacated. And,
What about a
13th Circuit-
willful evasion of knowing the truth? Would
Right.
you want that to be an affirmative defense?
I would say that there was no willful blindness here, if that's what you're alluding to. There was no deliberate action or active step, as I described earlier, that this court has required. Next, I'd like to address some policy considerations that the government brought up. As far as the fairness and integrity of the market, that's obviously important because the stock market is fundamental to our economy. But the notion that investors will flee the stock market just because people receive and trade on material non-public information is imaginative, to say the least. That's based on a notion of a paranoid investor, not a confident one that we see walking on Wall Street today. In any event, the government's effort to advance its policy agenda would be better left to Congress to define the outer limits of insider trading. I'd also like to address the point that insider trading, the adoption of the Newman standard, would significantly harm the prosecution of people who receive material non-public information. If you look at the cases since Newman came down 1 year ago, the government has had no problem getting convictions. In fact, actual experience has demonstrated that in every case in which a court has ruled on a Newman-based challenge to the sufficiency of a personal benefit, the government has prevailed. Thus, the government has encountered no trouble, including the gift theory of personal benefit, even in the wake of Newman. I'd also like to point out another point that a justice had. The 13th Circuit was mindful of the over-criminalization of our securities laws, particularly in insider trading cases, where a trader's success on his job depends on making snap judgments about tidbits of information they receive. These individuals cannot be required to track down every piece of information they receive. This would stymie the decision-making of these individuals and bring a stop to the liquidity of our capital markets. Are there any further questions? If I could briefly conclude, Ms. D'Onofrio's
Well,
conviction.
before you conclude, I do have a question.
Okay.
What was the instruction the court gave to the jury in this case?
Well, they gave two different instructions regarding the personal benefit and the knowledge requirement. The personal benefit requirement was impermissibly broad because it failed to require quid pro quo exchange in the criminal context. It included intangible things like favors, future obligations, reputational benefits, or the personal satisfaction of helping or strengthening a relationship with a friend. The court in Newman held that a quid pro quo exchange is required. In other words, the benefit must be of some consequence. We have to draw a line somewhere. You can't just make up a personal. It's
In other words, if
too easy
somebody
to-
has loose lips at a party,
yeah.
you shouldn't be able to convict somebody for listening to the person drinking a little too much with loose lips.
Yeah, that's a great way to put it.
Okay.
Also,
So the instruction's wrong because it didn't include solely quid pro quo.
right, and also included a reputational benefit, which was not contemplated by Dirks. They also mischaracterized the knowledge requirement of Dirks. While in the criminal context, Dirks did include imputed knowledge. Here, actual knowledge is required. The district court instructed the jury that the knowledge requirement was satisfied if the defendant actually knew or reasonably should have known. However, that's not sufficient here because the Securities and Exchange Act requires a willful mental state. And absent knowledge of the personal benefit, Ms. D'Onofrio does not know the existence of a fact that makes her conduct illegal.
So you would say that you don't put people in jail on what they should have known?
Right, you put people in jail for what they do know.
Correct.
So you can compare the example, I don't mean to beat a dead horse here, but compare the example of adult film director who employs underage actors unknown to him. This court has held in U.S. versus Excitement Video that a director defendant is required to know that the actors in a pornographic film were underage because the age of the performance is a crucial element to the crime. In other words, actual knowledge is required. If there are no further questions, I'd like to briefly conclude. Ms. D'Onofrio's conviction should be vacated because insider trading law requires both a fiduciary breach by the insider tipper and actual knowledge of that breach by the outside tippee. First, Mr. Adams did not breach his fiduciary duty to shareholders because he did not seek a personal benefit from Mr. Bookwalter, nor did he even intend to benefit Mr. Bookwalter. The relationship between the two was a casual social relationship. They saw each other only around 3 times per year. Second, even if this court determines Mr. Adams did breach his fiduciary duty by receiving that personal benefit, Ms. D'Onofrio is nevertheless innocent because she did not have the requisite knowledge nor the requisite mental state to be a culpable tippee. To criminalize Ms. D'Onofrio's conduct would directly contradict the willfulness standard of Section 10B and Rule 10b-5. She did not have knowledge of the alleged personal benefit that would make her trade illegal, and therefore she cannot be convicted. Thus, this court should vacate Ms. D'Onofrio's conviction because with the proper application of the law, there was insufficient evidence to sustain a conviction. Thank you.
Mr. Clifford?
Your Honors, I just have 3 brief points in rebuttal. First, it was stated that the should-have-known standard is not used within a criminal context. However, I would like to argue that it is. For example, if you look at state law for receiving stolen goods, a should-have-known standard has been used. And also, similar to this case, if you look at criminal medical malpractice, you have a case where you have sophisticated individuals who are licensed, who perform actions that they know to have broken the law, and they should have known that these actions do break the law. And if you look at those 2 examples, a should-have-known standard can be used. Additionally, the defense would have you believe that Mr. Adams, who had received a master's in business administration, was the chief financial officer for his, or I apologize, the chief financial director for his company, would have casually given out confidential information at a party to a licensed stockbroker. And I just do not believe that that passes the smell test, to be quite honest. I just do not believe that he would do such a thing without expecting something in return. And he did know
Well,
that
some people are like me, talk too much. And you get you a couple drinks and you start talking. Now I'm sitting there. Am I supposed to put earplugs in?
Well, the thing is, Mr. Bookwalter didn't put earplugs in. Mr. Bookwalter immediately walked over to one of the largest hedge fund traders at the party and gave her the information. He could have sat on that information like he should have, but he did not, and that information was transferred between the 2.
It sounds like you're making stockbrokers and hedge fund managers like judges. They can't talk about anything or do anything or.
I believe they're professionals, and we should hold them to a high standard, Your Honor.
Well, how high a standard? I mean, they're just stockbrokers.
But they have to be qualified in order they have to take a test. They have to be qualified in order to trade stock in that profession. And one of the first things they learn is you don't trade on insider knowledge.
Well, in that regard, the conversation between Ben and Alex, there was the question, does anyone else know this information? Doesn't that help your case?
The only people that would have known this information was Alex.
Because he said not yet.
Yes, as of then, was Alex, his employees, and the executive structure at ITEC. May I please have a brief moment to conclude and put in my 3rd point?
Well, sure.
The defense says that they're worried about the paranoid versus the confident investor walking down Wall Street. Those are not the investors that I'm worried about. I'm worried about the retired coal miner who's investing his pension in order to further his retirement. Those are the people that should work. All people are equal under the law, and we should look at these two groups of people and at least allow them access to the same information. Thank you.
We're not gonna get up and, you know, all rise and that stuff. We're gonna go in and, make a decision. Both arguments are awful good. Might be a tie, you never know. It was awful good.
I'm okay with that.
I'm stuck. Wait a minute.
Court is again in session. Please be seated.
You both made great arguments. As a matter of fact, you were both better than any of the lawyers, except for Professor Bastress, that argued here this morning. And I want to tell you a little secret. We called the dean in. We thought you were equally good. But it was decided we don't think under the bylaws we can call a tie. So with that, the winner is Colton Parsons. And I guess Colton, come up here. Now, you're big enough you can lift that. Turn around and get your picture taken.
Your name's not on there.
Now bring it. Just as you
Yeah, you can keep.
have the other.
All right, now, we want your adversary to come and have a picture with you because we really thought he was great.
I can address the court. Can you guys come down and take a picture with Colton too as well?
Certainly, certainly, absolutely.
Can we, minutes? I didn't see your name on there.
No, we didn't have it when I was at school.
It's all Joe Beasley's name.
Joe Beasley from Huntington?
Joe Beasley, my former partner.
Now check him, I want to see how I look, I don't care about that.
I've never seen you look bad.
Pull up, Michael, let's get a picture of Michael.
So yeah, you gotta move.
One more time.
Thank you all for coming. Did you say Colton, didn't you?
Yeah.
I thought you did. Isn't that what you said?
No, I say Colton, but I go.
Okay.